Welcome to National Security Law Today, the podcast of the Standing Committee on Law and National Security. I'm Elisa, always here in my individual capacity. The national security news linked to technology and our special intelligence tools has come fast and furious this past week. First, the Foreign Intelligence Surveillance Act, we'll refer to it as FISA Section 702, has sunsetted. So to explain this is Glenn Gerstell, who was former General Counsel for NSA. I can't think of anybody who would know more about this or be better positioned to discuss it. So Glenn, thank you so much for coming in. You're a master of this subject matter. We're glad to have you.
Thank you. Delighted to be back.
Let's do the basics first. So what is this provision again? Who does it allow to be intercepted?
This statute is a section of the Foreign Intelligence Surveillance Act that was added back in 2008 as technology changed to make sure that the United States was able to stay on top of foreign intelligence targets who increasingly used American telecommunications and internet platforms to communicate. And it turns out that not only do all of us in America use American platforms, but even the bad guys overseas use the equivalent of Gmail, Microsoft, Instagram, et cetera, because after all, it's really a testament to American ingenuity and innovation that essentially the world communicates on American communications platforms. And what that means is, as a legal matter, since we're in a legal podcast here, is that those American companies are amenable or subject to the United States government getting some kind of court order and telling them to please produce information on these foreign targets who use American communications device. So that's how Section 702 was born. It's a statute that I think is irreplaceable and has been described as the single most important national security operational statute. The intelligence that the United States government gets from Section 702, and I'll describe how it works in a second, is so critical that it constitutes about 70% of the president's daily brief. In other words, a very substantial portion of the information that our intelligence community gets and our Defense Department gets, State Department, Commerce Department, et cetera, about everything from North Korean sanctions evaders to narco-terrorists to what's happening in Iran, elsewhere in the Middle East, Russia and the Ukraine, all comes from 702 because of its ability to target specific foreign intelligence targets. So the way it works in real simple terms is the National Security Agency, along with the FBI, the CIA, and the National Counterterrorism Center, are entitled to nominate targets, foreign intelligence targets that they think are going to have vital information, and ask the National Security Agency to undertake surveillance of them, of their telecommunications, their emails, other electronic communication. It's a targeted thing. It's not a mass surveillance. Last year, there were about, maybe 300,000 foreign targets under this program, and all of their communications that are routed through the United States are potentially, I say potentially, subject to this surveillance, again, which is all through a series of court-approved procedures by the Foreign Intelligence Surveillance Court.
And let's draw a distinction here for people that aren't familiar with where this line of demarcation could be. This is distinct from ordinary 12333 collection. And by that, I mean collection for intelligence purposes under Executive Order 12333.
Right. That's right. This is a program that is specifically designed back in 2008 to comply with the confines of the Fourth Amendment, because even though we are targeting foreigners, no American can be targeted under this. Let me be crystal clear. There's no instance of an American being targeted under this. We're searching for communications of foreigners. The fact of the matter is that we need some legal mechanism to compel American companies. That's the directive or the equivalent sort of a search warrant that's given to them that says, please give us the inbox, so to speak, of a foreign terrorist, for example. And secondly, and here's the nub of the problem that has given rise to controversy ever since the statute was born, the fact of the matter is that some of those 300,000 foreigners that I was talking about who are targets under this will inevitably talk to Americans. Probably most of them don't because it's foreign to foreign, but some of them surely will. And certainly, for example, someone like, let's just say one of the targets is a Chinese spy who seeks to recruit people at Lockheed Martin and Boeing and other defense contractors to spy for China. Well, probably he or she is talking to Americans. Now, we might have a legitimate interest in finding out about that, but the fact of the matter is that American communications on the other end of the conversation get picked up and are subject to surveillance. And that, of course, has historically led to concerns over privacy.
Right. And that is generally referred to as something called incidental collection. It's unintended,
Correct.
But it's sort of the nature of global operations, period, in terms of people living overseas, having normal day-to-day communication with people here, but also, as you point out, recruiting or engaging in some sort of malfeasance in terms of reaching Americans for purposes that are not in our national security interests. This is also, you mentioned, distinct from FISA writ large, which requires a warrant and going before the FISC. It's a very different thing.
There are other sections. The original sections of FISA do require the obtaining of the equivalent of a search warrant based on probable cause to target someone in America, whether that's a foreigner or a U.S. person who's believed to be an agent of a foreign power. But again, that's because the Fourth Amendment protects everybody inside the United States, whether they're a citizen or an illegal alien. Interesting aspect of the Fourth Amendment. So that's other sections of FISA, not really subject to much controversy. And also, I might add, used far less frequently than 702, which, as I said, has hundreds of thousands of targets.
Let's talk about the implications of the statute lapsing. Does that mean there's no longer any kind of collection on these 300,000 people, some of whom are probably national security threats to the United States?
So the bad news is that the statute lapsed. Congress has obviously known about this expiration date, this sunset date, for years, and has been going back and forth trying to figure out whether it wanted to amend it, simply extend it, add some additional perceived reforms, deal with concerns of privacy advocates. They've been unable to come up with an agreement. As a result, the statute has lapsed last Friday, the 12th. That's the bad news. The good news, but it isn't the complete story, is that the statute has a provision in it that says, in effect, that court orders and directives that are on the books, so to speak, at the moment of expiration can continue to stay effective, stay alive for up to a year. So that means that the basic surveillance program can continue under the existing rules and regulations that the Foreign Intelligence Surveillance Court has already approved. So that means not only can we continue to do the surveillance on the targets that have already been nominated or selected, but even new ones can be added, assuming they are consistent with the existing regulations and certifications that have been approved. The bad news, and there's two pieces of it, one is very technical, is that it's probably the case that during the period that the statute lapsed, the FISA court, the Foreign Intelligence Surveillance Court, will not have the power to amend these procedures and regulations and certifications, which sometimes happens during the middle of a year when some technical problem arises and the NSA, including when I was there, wants to go back to the FISC and say, could you please change this? We've run into a problem. We need a technical change. And in this case, it may be the case. We don't know. This has never been tested. Maybe the FISC will say, sorry, we no longer have authority. That's probably a manageable problem in the grand scheme of things. The larger problem, and again, I don't want to overemphasize this, but nor do I want to minimize it, is that some providers, some telecommunications providers and internet providers have told the government, if there's a long period of elapse, you can't necessarily count on us to continue to comply, even though the statute, at least nominally, says that the orders remain in effect, because we want a court to specifically compel us to do so as a matter of our customers' privacy, our corporate policy, our desire for legal immunity. We're going to insist on a specific court order before we comply. We'll comply once you get a court order, but in the meantime, we're gonna fight this out in court and see who's right. And during that period, whether it's 3 days, 6 days, or 4 months, we don't know what we're going to be missing if one or more telecom providers or internet providers fail to give the government that information. And you can imagine, just very quickly, in the terrorist context or cybersecurity context, where 702 is of critical importance, that missing a day's collection or a week's collection or a month's collection in fast-paced areas like that could well be significant. I'm not saying it's going to be. I'm just saying it's a risk that we're taking.
I guess a sort of not doomsday, but certainly catastrophic scenario would be that information regarding, say, attack on a grid was passed during a period of time when there was no collection. And the US could have anticipated that and done something about it, and it's missed because of a loss of access to this information.
Sure. It's easy to envision situations in which we would look back and say, gosh, had we not missed that, we could have avoided something. And especially in the cybersecurity area, where sometimes the FBI will learn of a ransom attack on, say, a hospital, and then want to very, very quickly search its computer database and 702 targets to see what other hospitals might be next on the list, or where is the cyber criminal gang operating from overseas, what other servers have been infected, what's the path of this malevolence. And if they can't move really quickly, and by that I mean within hours and days, who knows how many more victims will fall due to the inability to get information. Again, not saying it's going to happen, but I'm just saying we're taking a risk. And for me, it's very hard to see why we should accept any risk in this area since it's completely controllable. This is, to use the World Cup analogy these days, an own goal.
There is one statute, though, that references sort of the receipt of information or collection of information as being an exception generally, but it's referring to 12333 style collection, and that is the Stored Electronic Communications Act, ECPA. Specifically, I think it's 25112F. And this is not that. It is something else entirely. So I'd like to just ask you a question, because everything in Washington is horse trading, I'm sad to say, but it is. It's not necessarily what the American people imagine. And by that, I mean, there were a few things that have been reported, and I don't even know if they're accurate. But one of the things in the run-up to the reauthorization of 702 was the president's statement that he was going to put Bill Pulte in as ODNI, and Pulte is not a person with national security experience. What were some of the factors in this happening, as far as you know?
So, look, this has always been a contentious reauthorization ever since the statute was first adopted. It's been reauthorized several times, almost always with declining majorities. It started off with a very strong bipartisan majority, and bit by bit, people have chipped away at it over concerns of privacy. The FBI didn't do itself any favors with having some abuses earlier on. And so the net result is that compromise in this area has always been very fraught, very difficult. So much so that in this last reauthorization coming up this year in 2026, Congress had to punt and kick the can down the road twice after the original expiration earlier this year. And it really started to look like a rough compromise had finally been reached between Republicans and Democrats to get enough votes to go ahead and do the reauthorization with probably some minor amendments, not very substantive, but there would be some amendments, enough to placate those who wanted to see some changes. And just at that time, the president nominated Mr. Pulte to be the DNI, which enraged not only Democrats, but a fair number of Republicans who thought that he was just simply not qualified for the position. They obviously made comments to the White House about this. Trump decided not to change immediately, but that was just enough to sink whatever fragile compromise and consensus had already existed on 702, and thus the statute lapsed. I think what's probably going to happen now that another person has been nominated, Mr. Clayton has been nominated, who's a well-regarded lawyer in New York circles, the United States Attorney for the Southern District. I suspect he'll probably get confirmed. There'll surely be some opposition, but I suspect he'll probably get confirmed. But the fact that he seems to be roughly acceptable to many Republicans and Democrats is probably going to be just enough to remove the annoyance associated with Mr. Pulte being nominated and probably allow Congress, I hope, within the next month, perhaps even sooner, to go ahead and put that compromise back in place for reauthorizing 702.
One note that I just read was that the president also wanted to link the reauthorization to his voter ID legislation that he would like to see passed.
Right, the Save America Act, yes.
So, I mean, in that regard, it feels like what has happened is there are some of these must-approve statutes every year, one of them being the National Defense Authorization Act, which is always larded up with writers. It feels like this is A little gratuitous, but I don't know. What's your opinion on that? And is it actually sort of being tagged on here as a condition slash rider of reauthorization, or I should say like a parasite of reauthorization, that kind of little fish that gloms onto the whale?
Well, the president has been trying to get the SAVE Act, the Election Security Act, attached to various other pieces of legislation earlier this year. That hasn't happened. The statutes have gone ahead and been adopted without that. I think this is another attempt to do so. He's probably, I imagine, a little annoyed that there was such a backlash to Mr. Pulte's selection for the acting DNI that he's thrown something else into the mixing bowl here. But I think it's pretty clear from what I've heard from members of Congress and staff that they're not interested in linking the two. I haven't heard anyone who says we should not reauthorize 702. There's no one who says, let's just get rid of the statute. Nobody's happy that it's expired. They all recognize they need to come up with some compromise, some agreement that gets enough votes to get it across the finish line. And adding the Save America Act, the Election Security Act, is obviously going in the wrong direction in that regard. And they know that.
Any last words on this topic, Glenn, or should we all just stay tuned?
I think it's stay tuned. This is a critically important statute. We shouldn't be in this place accepting whatever risk we're taking. Hopefully small risk. Hopefully it's not going to be consequential, but we don't know. And that's the problem with these kinds of surveillance things. You only need to miss one thing for it to have a big consequence. Hopefully we're not going to have that. And let's just assume that within the month, if not sooner, we'll have the statute back on the books.
Okay. Well, we'll all stay tuned. Thank you so much.
Thank you
again. It's always great to talk to you about these things.
Same here. Thank you.
Okay, let's move on to the rest of national security news, most of which is focused on geopolitics, but AI as well. And speaking of which, and major developments on geopolitics and business, tonight, as we're recording, there are claims that we have some sort of an agreement with Iran, the conditions of which apparently involve Iran receiving some of its own money, which is held in financial institutions outside of Iran. This should sound a familiar note to historians who may remember that it wasn't the hostages who were taken, back in the 1970s and not released until 1981, I think. They were released only after the Algiers Accords and Iran's money was freed up. So this is kind of a repeat pattern of conduct. And we will do a podcast at some point in the future and talk a little bit more about that history with the Algiers Accords, which for people who work in the IEPA area or on sanctions, they're probably quite familiar with that history. In any event, let's go on. It appears that President Trump and Vermont Senator Bernie Sanders have a meeting of the minds on an issue. That's right. It's true. I'm not saying they're throwing back a beer right now and talking it over, but they appear to agree that the United States government/treasury should take a direct equity stake in American AI companies, including Anthropic and OpenAI. Anthropic was supposed to be, as you know, on a list of Pentagon-banned companies, and a little bit more on that in a moment. So it would be interesting if America was sort of a stockholder in a Pentagon-banned company. Now, Sanders' bill proposes an American AI wealth fund, whereby the Treasury would take stock in 3 companies: Anthropic, OpenAI, and xAI. Now, Sanders argues that this would give the public a direct role in determining the future of AI technology, and it would remove power from big companies and place it in the hands of the people. Yes, I am about to sing from Les Miserables, even as I say this, but he characterized the owners as oligarchs, big tech oligarchs, and he's saying that this would give trillions of dollars to the Treasury to improve the lives of all of us. In support of his legislation, he cites the statements by Anthropic CEO Dario Amodei and xAI CEO Elon Musk about how the U.S. government's ownership would create universal high income. Now, on another topic, various U.S. presidents have suggested to European NATO members that they needed to beef up their defense spending in compliance with the NATO treaty's requirement that members spend 2% of their gross national product, or GDP. I can't remember if it's that or something else, but 2% of what they have. Germany, which is one of Europe's largest and wealthiest countries, went through a period over 30 years of deindustrializing. It even shut off its robust nuclear power system. It switched to operating power through dependency on Russian pipelines. But Germany appears to suddenly be moving in a different direction now. Arms maker Deal is in negotiations to build Ukraine's Flamingo missiles for Firepoint, which is Ukraine's leading weapons manufacturer. And this could replace the U.S. Tomahawk missiles that were due to deploy to Germany this year, along with U.S. troops. This geographical diversifying of weapons production is also the topic of discussion in the United States, where the head of the Defense Technology Group and Durrell Industries has called for a reset of America's strict arms export regime to make it easier for allied nations to produce U.S. weapons. I guess the question here is, which are the allied U.S. nations? Would that be the UK and Canada? I'm not so sure. Anyway, Brian Shimps, that's really his name, Shimps, chief executive of the California-based group, which was valued at around $60 billion last month, said the need for low-cost weapons manufactured at scale means allies should be enlisted to help boost production capacity, which I guess the Germans are doing, right? All right, so the United States continues to need certain minerals, as you know, for AI chips used in intelligence compute and weapon systems, and many of those minerals do not exist within the borders of the United States. But back in February, the U.S. signed a critical minerals security agreement with the government of the Democratic Republic of Congo, not a bastion of democracy or progressive values. But there is an analysis by the Peterson Institute that discusses the risks of the deal and the potential positive outcomes. First of all, they think it would grant American firms access to Africa's critical minerals, quite obviously, in exchange for military assistance, sort of like NATO Light or NATO Congo or some version of that. Anyway, while such an agreement might appear attractive, it would come with a substantial risk that echoes past entanglements in complex and unstable regions. The Peterson Institute suggests the U.S. should instead focus on repairing relations with Canada, a critical mineral powerhouse. And by the way, they're just right here. And engaging with countries like the DRC on economic and diplomatic terms rather than militarized ones. They point out that the U.S. needs critical minerals, specifically lithium, uranium, and copper, for both economic resilience and national security reasons. They're necessary for advanced energy and defense technologies to such a degree. There's not much we can do. We got to get it elsewhere. And we are keen to reduce our dependence on China, which frankly is the world's major refiner of critical minerals. You can't just get them. They're in a bunch of dirt and mess. So the DRC's proposal could help the U.S. diversify its sources of minerals. It would provide some domestic employment opportunities. And it could, I guess, diminish the risk of rebellion there. But private companies going into the DRC are now doing so, interestingly enough, not just with the United States, but in partnership with the United Arab Emirate companies. So this raises questions about how the U.S. would provide security and who might benefit from this relationship. Would it be the American people or not? It's not entirely clear. And then there's always a secondary conversation. Sounds a little bit like the East Germany, let's get along with Russia conversation about strengthening ties between Emirate nations and the U.S. in our strategic interests, since we no longer have bases in Saudi. We recently talked to Gary Korn about cognitive warfare and how social media has been used to gin up conflicts in Ethiopia and Myanmar. And a new article looks at how social media, in particular X, fueled racist violence in Northern Ireland. Senior government officials have squarely laid the blame for some of the unrest on, quote, bad faith actors who used social media in order to call out individuals to participate in hooliganism and violence in the streets. Now, this just took place last week. U.S. billionaire Elon Musk, who owns X, was among those sharing posts about the attack, including one from far-right activist Stephen Yaxley-Lennon, who goes by the name Tommy Robinson, who called for these nationwide protests. And in the UK, Tech Secretary Liz Kendall said Wednesday that the government will legislate to cut the time social media platforms have to remove illegal content that's circulated online. It's an interesting notion that you give them a timeline, you get that stuff down, or there's some consequence. It's an interesting thing, shortly after which Keir Starmer, the Prime Minister of the UK, suggested that there should be a complete ban on access to social media on children, minor children, I believe under the age of 16, but I welcome correction from any listener who's looked more closely at this. In any event, I think that's about a wrap today. There's one other thing that I wanted to mention in the area of national security news, which is we talk a lot about CFIUS, and we also talk about Section 721 of the Defense Production Act, the DPA of 1988. There has been a lawsuit to force an unwinding of two companies, one of which I cannot pronounce, but I think it's Sui Rui, who acquired a company called Jupiter. Apparently, they were told you have 120 days to unwind this transaction because it presents national security concerns. There was CFIUS review. They were given 120 days to do it, and they've refused to unwind, or they haven't unwound. And there's now an enforcement action. This is worth paying attention to. I think this is going to be the kind of area of law for a lot of young lawyers you might take an interest in. If we're going to force companies to unwind, and there are some interesting details about this particular company and when they were told to unwind, which was well after the deal was inked. You may want to keep an eye on this case. We certainly will, and we'll probably have some of the experts on to talk about it. But in case you're interested, there is also a Congressional Research Service report on this, which if you're new to it, might be worth taking a look, and we can hyperlink that in the notes to the cast. So thank you so much for listening to NSLT. You should subscribe to NSLT on Apple Podcasts, Spotify, or Amazon. Please write us a review. If you like us, give us 5 stars. Share this episode with a friend who values civil discussion and factual conversation over clickbait and shouting. I imagine you're sick of it too. The writer, producer, and host of this podcast is me, Elisa Poteet. I'm always here in my individual capacity, but our editor and producer is Frances Burkham. My co-producer is the amazing Holly McMahon. She is tireless, freakishly tireless. I don't know what she drinks, eats. I haven't watched her that closely, but I'm going to. Our program manager is the lovely and energetic Antasia Hawkins-Blakeney. Social media and research support comes from Alana Coopersmith. But really, we can't do this podcast without the Standing Committee on Law and National Security. These are the greatest national security lawyers in Washington. They care not a whit about politics. They care about national security and national security law. And that's why we have this podcast. I hope at some point, listeners, you get a chance to come to one of our events, our breakfasts, anything, where you get a chance to meet some of these amazing people because they are fully inspirational. Thanks for listening. We'll see you next time.
The views expressed on National Security Law Today have not been approved by the House of Delegates or the Board of Governors of the American Bar Association, and this recording should not be construed as representing ABA policy.